Welcome to Real Estate Real Connections. I'm Julie Miller. Protecting your assets and securing your family's future can be tricky. Today I'm talking to Shawn Ryan, a seasoned real estate and estate planning attorney, about transfer on death deeds and trust. Shawn, thank you so much for being here today.
You're welcome.
Well, let's start with the basics. What exactly is a transfer on death deed?
A transfer on death deed is, as the name suggests, a deed that transfers real estate when the principal owner or owners pass away. And so the goal of a transfer on death deed is typically twofold. Obviously, to distribute assets, the real estate, to the persons who are intended to receive it, but also, and probably most importantly, to avoid probate and make the transfer smooth, efficient, and at potentially the lowest possible cost.
Okay, so I guess that answers my next question of why someone may want to use this. And is it economical? Is it the easiest instrument to use?
It can be, and as with many things, there are often trade-offs involved, and so I guess the question would be why would a person want to avoid probate? That's the obvious question, and the answer is for typically timing and cost. Meaning that the probate process is I'll give it a summary. In summary fashion, it is a court-supervised process by which the assets of a person who has passed away, the decedent, are transferred to that person's intended recipients. So going through probate is not really the end of the world. People do it all the time, and we have a system in place, and it's a known process. But it can be more expensive than some alternatives. So the first alternative that we're talking about is, as you said, the transfer on death deed. And what that accomplishes, if it's done correctly, is to take it outside of the probate process. The probate process, I've seen studies that say nationwide, the cost of probate can run from 4 to 10% of the assets being transferred. It doesn't necessarily need to be that high, particularly in Indiana. I think we have a good system. But nevertheless, there are costs involved, including the time delay in being able to close out an estate. So the transfer on death deed, if done properly, is an alternative to going through probate.
Okay, so I know there's always a lot of questions about when exactly does a transfer on death deed need to be prepared and recorded. So can you talk a little bit about what that process looks like?
Yeah, that's a good question, and it's very important. The main thing, the main thing to remember is that it must not only be signed during lifetime by the person who's doing the transfer, but it must also be recorded during that person's lifetime. This is a rule that applies in Indiana, so this is very Indiana specific. And so the requirement is that it would, of course, be in writing on the deed. It has the proper language. There are guidelines in the Indiana statutes that say what is an effective transfer on death provision in a deed, and then it needs to be signed properly, meaning in the presence of a notary public, and then recorded with the county recorder's office. So that all has to be done during lifetime. You can't, with some other deeds, again, this is a summary, so it's kind of a generalized statement, but some other deeds you could sign it in the presence of a notary, put it in a drawer and tuck it away and record it at a later date. But with the transfer on death deed, it needs to be done before the person passes away. Okay,
that's good information. So if I were to consider doing a transfer on death deed, can you give me an approximate ballpark of costs that would be involved with doing something like that?
Certainly. It depends on what you're doing, who you're dealing with. But to say a general range, I think you would be looking in the range of hundreds of dollars rather than thousands of dollars, which isn't to say somebody might charge more to give additional advice or as part of a package. Typically, I would say the transfer on death deed is often a part of a larger estate planning package, that would deal with powers of attorney, healthcare directives, wills, trusts, things like that. So it's often included or related to additional work. But the deed itself, I would say, it should be more costly than a typical simple quitclaim deed because there's more involved and more at stake potentially. But I would say in the realm of hundreds of dollars rather than anything higher than that. Now, you'd also want to add in the recorder's fee, auditor's fee. So depending on the county and the current rate of fees, that could be an additional, $7,500 of transfer fees or recording fees. But those are relatively nominal.
Very good. I'd like to kind of shift gears a little bit and talk about trusts. So can you explain to the viewers what exactly is a trust and why would someone consider putting their real estate assets into a trust?
Certainly. A trust is an agreement, and technically speaking, it would not need to be in writing, but you would want it to be in writing for it to be enforceable, particularly with respect to real estate. That's going to involve a written document. So a trust is an agreement between somebody who is setting up the trust, they're called the grantor or the settlor, and the trustee, who is often the same person as long as they're alive. So an individual or a couple could set up a trust whereby they create the trust, and then during their lifetimes they administer the trust, and even during a period of incapacity, they may be a beneficiary of the trust, but then you also would typically have a provision that dictates what happens when that person or the persons pass away. So if it's a married couple, it would typically be for the benefit of the surviving spouse, and then distribution to or some other accommodation for their children or grandchildren or a charity or any combination of those things. Okay. So the general topic that we're talking about is the most common type of trust. You may have heard it called a living trust. It's also known as a revocable trust. And that simply means, in contrast, a revocable trust means it's in contrast to an irrevocable trust. Sometimes done, but the typical trust that folks would be looking at first would be the standard living revocable trust. So it's an instrument to accomplish the transfer of assets or the holding of assets under certain terms that are set forth in the trust.
So how would I decide if a trust is right for me personally or my assets? How would I make that determination?
Again, another good question. The general way that I approach it, and people have different viewpoints, there are certain people who approach it and say that a trust is appropriate for everyone because of the benefits, and they're really pushing the use of a trust, and they're right when they say all of the potential benefits and the things that can be done through a trust. It's a fantastic instrument. The one thing that sometimes they undervalue or underanalyze is the cost. It costs significantly more to set up a trust than it does to use a transfer on death deed or some other form of joint ownership or things like that. Sometimes it could even be comparable to the cost of going through probate. So it's maybe an even trade. The cost of a trust is typically paid at the time that you're setting it up. So it's a cost that the person pays during their lifetime to save money down the road and save time down the road and make some of these benefits of avoiding probate down the road. Typically, they won't recognize that, but their beneficiaries, potentially children, grandchildren, a charity, they'll recognize that after the person has passed away. So it really comes down to a difference in cost. Okay. The one other thing that comes into play with a trust, as opposed to a transfer on death deed, would be the flexibility that's involved. For instance, let's go back to the transfer on death deed. Typically, you would be able to say, I transfer it to myself. I'm keeping the interest during my lifetime, but upon death, it goes to X, Y, and Z. Let's just say it's your children. And it goes to them in equal shares, and if they predecease me, then to their descendants. And that's very cut and dried. It's clear what's going to take place. But it doesn't have the flexibility that trust does. What I mean by that is, let's say that you have a grandchild who has special needs. Not you, but somebody who has a grandchild has special needs, and they want to make a provision. Well, if this happens, I want this held in trust until a certain age, or I don't want to render them ineligible for benefits that they're receiving. that won't fit into a transfer on death deed. It's just not the right vehicle. So the trust, when I say gives you more flexibility, it allows you to fine tune what that distribution could be, much more so than a transfer on death deed. So that's where the flexibility comes in.
Okay, so we've talked about some of the benefits of the trust. Are there any potential pitfalls to using a trust?
Well, it has to, I mentioned the cost already. There's a little more work in setting it up. The second pitfall that is probably the most common thing that happens is a trust is only valuable if you put your assets into the trust. And so the trust is like a bucket that and I may end up mixing metaphors here, but the trust is like a bucket that you're pouring things into, and then at the end of your life or whenever these triggering events occur, you're pouring things out of the bucket and making that distribution. So you have to use that same phrase, you have to put the things into the bucket. So if you have real estate and you want to use a living trust to transfer the real estate, then you also have to deed the real estate into the trust to accomplish that. If you have a bank account or other investment accounts, you have to title those assets into the name of the trust to accomplish that. And then along with that, there are other assets that typically, like personal property that does not have a title. You can just do a certificate or a provision in the trust that says, I'm putting my personal property into the trust, and designating those things like that. Or there may be assets like a life insurance policy that already has a beneficiary designation where that would go directly to the beneficiary, but you may have the trust as potentially a backup beneficiary on those types of things, like a retirement plan as a backup to your other arrangements or an insurance policy, things like that. So the pitfall would be if you spend the money, set up a nice trust, put it into place, and then forget to transfer the assets into the trust. So that's typically, when we handle those, we work with folks to try to make sure, okay, here's your checklist for accomplishing these things. Also do a deed of real estate into the trust and cover the titling of the accounts and things like that to make sure that you don't fall into that pitfall and everything's properly put into the trust so you can get the benefit from it.
Great, really good information. So can you tell our viewers a little bit about Shawn Ryan and who you are and your credentials?
Sure. I was born in South Bend, grew up in Elkhart, went to Concord High School and Notre Dame for undergrad and law school. And I'm licensed to practice in Indiana and Michigan and Illinois. Everything that we talked about today was generally specific to Indiana, and Michigan has slightly different laws in place with respect to transfer on death deeds. They do not have transfer on death deeds per se. They have ladybird deeds, which it's a different animal. It can accomplish some of the same things, but there are significant differences. But anyway, so I practice primarily in Indiana, but also in Michigan and sometimes in Illinois. I do a lot of estate-related work, real estate, estate planning, civil litigation involving those subjects, and a few others. And I live in the area, have a wife and a son, like being in the community.
So your office is located in South Bend. So if someone watching would like to reach out to you for a consultation or talk to you about their estate planning needs, how can they find you?
You can give me a call, 574-289-0909. And we typically, if somebody wants to talk about things, we'll consult, give them information. The meter doesn't start running until we agree that, we're going to move forward or do things like that. And usually the process would be starting with collecting information through a simple questionnaire, fairly simple questionnaire, and getting the relevant information, and then making some proposals about here's what we could do, here's what we recommend, and what the time frame would be. And a lot of times that's triggered by somebody has an upcoming piece of travel. Maybe they're going to Europe, or they've had an illness in the family, or they recognize something, and so we try to turn those around as quickly as possible, and even on an emergency basis if necessary, if somebody's ailing.
Very good. Well, thank you so much for spending some time with us today and your expertise. We really appreciate it.
Well, you're welcome. Happy to do it.
Thank you for watching this episode of Real Estate Real Connections. I hope you enjoyed it. Remember to like, share, and take the opportunity to empower others to make informed decisions in their estate planning journey. Please visit metropolitantitle.com to learn more about escrow, title insurance, and all things real estate. Until next time, stay informed, stay empowered, and stay connected.